Hello, I'm Dr. Daria Sharkova, and today we have the ninth episode of our series, Houston, We Have a Solution, with Justice Michael Massengale, and we will discuss Texas International Arbitration Statute. Can we make it even better?
Yes, we can, and we need to.
Okay, Michael, first of all, tell us about yourself, how you ended up in Houston.
Sure. First of all, I want to say thank you for inviting me to participate in the webinar series. I'm very excited about Houston Place of Arbitration series and everything that you're doing, Daria, to promote Houston as a seat. I think it's incredibly important. And I also want to say we're just thrilled to host this at the JAMS Houston International Arbitration Center. I know a lot of people who practice in Houston have had a chance to see it now, but we want people to see and know that we're open for business and we're willing to host proceedings, not only JAMS administered arbitrations, but for international proceedings. We're willing to make the facility open for any international proceedings. So glad to have you here in our space, which we're really proud of. How did I end up in Houston? I'm a Texan, but not a native Houstonian. My father was in the Air Force, so growing up, I lived in a lot of different places. Both of my parents, though, were from Texas. And when I was growing up, my brother and I, we knew we were from Texas, and Texas was the best state, the state that you wanted to be from. And anybody who's from Texas will understand that kind of state pride that we all have as Texans. I went to law school at the University of Texas in Austin, spent the summer after my second year with a firm in New York and another firm in Houston. And I didn't really have any connection to Houston before that. But I ended up with a choice between law firms in New York and Houston. But I also had an opportunity, which was just the best way to start a legal career as a law clerk working for a federal judge on the Fifth Circuit who was based here in Houston. And so when I came for my clerkship, I got to take the city for a test drive. And I wasn't sure when I arrived, but about halfway through my clerkship, I had decided I would stay. And it's a decision that I've never regretted. Houston is an incredibly great place to practice law, and it's a great place to live. So I embrace Houston now as my hometown. I've lived here more than half my life now.
And Michael is the best person to speak about arbitration in Texas because not only he did the federal clerkship, but also was a judge at the Texas Court of Appeals, right?
That's right. So after my clerkship, I went to a large, well-known law firm called Baker Botts and was a trial lawyer there for 10 years. And then after that, I was appointed by Governor Perry and served on our state intermediate court of appeals based here in Houston for 10 years. And I have to tell you, because I'm a person who's a little bit nerdy about law and I've always enjoyed writing, being an appellate judge really was a dream job. I'm just so grateful to have had that opportunity to do it. And one of the best things I've done. So I like that as an arbitrator, I continue to get to write, and it's one of the more fun parts of the job for me.
And very lucky to get some of your wisdom today on Texas arbitration statute. So not a lot of people know that Texas has arbitration statutes, right? And we have today, I see that we have participants from different countries. So could you please tell us what's the legal framework here for arbitration?
Sure. And I want to start with a big picture concept, and I think it becomes really important when we talk about how we can improve and innovate with our local state international arbitration law. But the American government is organized around a principle of federalism. We have a federal government with a federal constitution and federal statutes that govern many parts of our lives and of business and commerce. But we also have in parallel 50 states, 50 state legislatures, 50 governors, and different regimes of law that do vary, sometimes very significantly from state to state. So there's a federal arbitration law that's very familiar to people. It's called the Federal Arbitration Act. It just had its 100-year anniversary. And that's a very important foundational law for the practice of arbitration in the United States. It provides a foundation and I think sort of the key procedural structure for arbitration. But there is a lot of detail about how arbitration practice happens that is not addressed by the Federal Arbitration Act. And so that's where these state laws come in. They fill in a lot of gaps. They're not, for the most part, they are not in competition. They're not in conflict. They work in harmony, and the state arbitration laws are complementary to the federal arbitration law. And so we have a Texas arbitration law, and in fact, we have two distinct statutory schemes. We have a general domestic arbitration law, and then we also have a distinct international arbitration law. And so it's important, particularly for practitioners, to be familiar with all of these and know how they work together. But just to circle back to this idea of federalism and the opportunity it presents to us, a lot of the idea of this and the genius of American government is that for some policies and some rules, it makes sense to have a uniform law across the entire country, and everybody benefits from that. We also benefit from allowing states to have different laws that reflect policy preferences, local needs, the needs of local practice. And so we're able to do that. And, you know, I think for people who are familiar with domestic arbitration practice, some states are more pro arbitration than others. Texas is very pro arbitration. But there's also this concept of laboratories of experimentation. Mm-hmm. And what it means is one state can choose to be an innovator and enact a law, and other states can watch to see how it turns out before they enact it. And so this idea of laboratories of innovation between the 50 states, they can compete with each other, they can have competing ideas, and then it provides a record where people can look to see this worked here, it didn't work there. So we've been an innovator in Texas because not every state in the United States has an International Arbitration Act. But part of what I was hoping to talk about today is we've got opportunities not only to bring our statute up to speed with current best practices, but even look beyond and make Texas an innovator for hospitality for international arbitration proceedings.
And we have everything to do that, right? But coming back, so did I understand correctly that we have 3 levels of legislative framework in Texas for arbitration? So we have some cases where the Federal Arbitration Act applies. Then we have cases where the domestic part of Texas Arbitration Act applies, and then the international, right?
Right. Although I would call it 2 levels because you have the federal level, which is overarching. And something that is important to understand is that for the most part, anything a state enacts that's in conflict with the federal law is going to be preempted. So the federal law is supreme, but as long as you're not in conflict with the federal law, you're not interfering with the general pro-arbitration policy that's established by that federal law, the states are free to innovate and enact unique laws that operate in support of arbitration. And in Texas, 2 avenues for that, domestic and international.
Domestic and international. So if you have a seat of arbitration in Texas, or as we all want in Houston, how does the Federal Arbitration Act interact with the Texas Arbitration Act?
Very frequently, they operate in parallel. And so the Federal Arbitration Act provides some very important, as I was saying, foundational procedural guardrails. Usually the FAA is what you're looking to enforce an arbitration agreement or to stay litigation pending an arbitration. It's a statute that you look to to confirm an arbitration award and try to enforce it through the court system, or alternatively to vacate an arbitration award if there's grounds for that. And that's a very, very important part of the statutory structure in the U.S. There's a level of more detail. For example, can I get access to the courts to enforce a request for documents? Or can I enforce a subpoena and take a deposition in support of an arbitration? The FAA doesn't speak to all these details, but most of the state arbitration acts do. And then one other thing that's interesting to know is that the parties to an arbitration agreement, they can choose the state. So, and this kind of goes to the importance of a seat of arbitration. Where you have your hearing doesn't necessarily matter, but when the parties choose a seat of arbitration, they're choosing the law that applies to the procedural framework. They're choosing the courts that are going to decide disputes. They're choosing a judicial system that either is or is not very reliable and acts, either does or does not act quickly in support of arbitration. And so so that choice of where to seat your arbitration is a very important one.
Where can people find the Texas arbitration statutes? Because we have people who are asking, well, how do I consult it? Where do I find it?
Well, like everything these days, the easiest thing is just to get on your internet browser.
What will we put in the browser?
Well, you could type Texas. Well, okay, so I haven't said this. The part of the Texas code where these statutes can be found is called the Civil Practice and Remedies Code. The domestic code is Chapter 171. The international code is Chapter 172. And, if I'm not using Westlaw or another service, I just go to the state legislature's website. It has the most current version of the statute, and it's free and it's easy to navigate. And so it's not hard to find.
That's great because, sometimes people hear Texas lawyers speak about this chapters 170 to 171 and don't understand what's that, right? Now they do.
Civil Practice and Remedies Code is the part of the Texas body of statutory law that you want to look in.
And so what's their interactions? Do they interact separately? I know because I'm a French lawyer, I know that French Civil Procedure Code has special provisions on the domestic arbitration and on international arbitration, and they define in which situation each applies. So do we have the same in Texas?
Yes. So Chapter 171, which is the General Arbitration Act, that's the default law that applies. And then Texas at the time was very forward-looking. It was Texas enacted its international arbitration statute just a few years after a model code that's been very influential was adopted. And many people will be familiar with the UNCITRAL model code. It was originally enacted in 1985, and just 4 years later, in 1989, Texas adopted the UNCITRAL model law with some modifications and incorporated it into Texas law. And when does it apply? It's the same standard that's found in the model law, so it's going to be a standard that should be familiar to international practitioners who are familiar with the model code. It has to be an international commercial arbitration, and there's two elements to that. Is it international? Generally, if you're in Texas, you can just ask yourself, is there somebody outside of Texas or outside of the United States to make it international? But the code has a definition that makes reference to where the parties have their places of business, or if the place of arbitration is outside the parties' home states. But basically, you're looking for parties from two different countries. Then it has to be commercial, and that's defined very, very broadly. It can be supply of goods and services. It can be construction. It can be engineering. There's actually a little laundry list, but it's very broadly framed. International and commercial is what you're looking for to get under the statute.
So if the parties are from different states, for instance, Oklahoma and Texas, will the international part apply or the domestic?
It would be domestic. The different states of the United States aren't considered states for purposes of Chapter 172.
That's great to know. Oh, and another question.
Well, it's the kind of thing that if you weren't a practitioner in this area and you just picked up the state, or you just picked up the statute, it's easy to understand that people can be confused about that. And as a judge, I did see some strange arguments. But if you don't know and you see the word state,
Thank you for this comment. And you talked about the seat of arbitration. You already explained us that seat, it's not the physical location, it's what the parties put in their contract. So I've been wondering for some time already, Houston being an energy capital of the world, right? We have every company presented here from Equinor, former Statoil, to Aramco, which is the Saudi Arabian oil company. But why do we still behind such seats of arbitration as Paris, Singapore, and New York? And more importantly, what, in your opinion, can we do to get there?
Big question. Big question. I hope we'll spend the hour covering that. Well, you are right, and many of us share the view that Texas has many strengths that should make Houston a very, very attractive seat for international arbitration, particularly in these areas of our local strength, energy disputes, Latin American disputes, and the seats that you've identified, some of these are the global leaders, and I don't think the point is to say that any of these places are bad places to host a dispute, and they are certainly very familiar and comfortable to practitioners. But I think there's very good reasons that Houston should be in the conversation, and people should be thinking about and proposing Houston as a seat of arbitration. If you look to what the users of arbitration are saying is important, what are the critical factors that they're looking for in a seat? Houston ranks very, very well. And there are some surveys that the Queen Mary School is doing on a regular basis, which provides really, really helpful data on this. But we know that some of the critical factors are support for arbitration by local courts, the neutrality of the legal system in the seat, and a track record for enforcing agreements and awards. Well, I think the American legal system in general is trustworthy on these accounts, but Texas in particular has a great reputation for being very pro-arbitration, not only as a matter of legislative policy, but as can be documented through decisions of courts. The Texas Supreme Court is very consistently supportive of arbitration, a very pro-arbitration court. And of course, that is the court that sets precedent for all civil disputes in the state court system in Texas. We also are blessed in Houston to have really outstanding federal judges, and many international disputes will end up, if issues are litigated, they'll often be before federal courts. We have great federal courts, and the Fifth Circuit Court of Appeals, the one I clerked for, our regional federal court of appeals, is similarly very pro-arbitration in its approach, very faithful to the FAA's policy of supporting arbitration, and we have that reputation, and it's well deserved. In addition, I think anybody who follows business news knows that there's a lot of momentum right now in Texas to modernize our statutes and maximize the attractiveness of Texas for business. And one of the most visible features of that is that we've recently enacted a business court, and we can talk about that a little bit. But the business court is a court that will have appointed judges who have experience and concentrated expertise in the areas of law that are pertinent to international commercial disputes. And this is going to be a stabilizing force for the Texas judiciary that is going to instill increasingly greater confidence that people can bring their disputes to Texas and know that if they end up in the court system, they're going to be in front of competent judges who are prepared to, when they receive a dispute, something that needs immediate attention, needs immediate aid for arbitration, they're not going to be hearing about arbitration for the first time.
Michael, we have audience today from Africa, Latin America, Europe, and Mexico, our closest
Outstanding
neighbors. So could you please explain us in simple words what's the Texas Business Court and how these people can use it?
Sure.
For instance, you're sitting somewhere in Mexico, you have this case with a party from Texas. How can you use the business court?
Sure. Let me first sort of draw some parallels because Texas, as everybody knows, is a really big state. And we have local courts all over the state. In Texas, we elect our judges. And if you compare that situation and just sort of the facts of the geography of Texas to another state that's known for being a leader of business law, Delaware. Delaware's got a reputation for having highly sophisticated laws that impact business. But very critically, people know that the judges of the Delaware courts are the best of the best in terms of knowledge and experience and capability to handle sophisticated commercial disputes. And it's a reason why Delaware is a trusted jurisdiction. People chose it to incorporate their businesses because they know they have the backstop of that Delaware judiciary. Well, in Texas, if a lawsuit's initiated in any part of the state, we've got over 500 civil district judges around the state. You can't have that kind of confidence that your dispute is going to be in front of somebody who is familiar and will have a sense of what to do. And if you have a complex commercial dispute in front of the wrong kind of judge, it can really extend the amount of time and the cost and the burden to eventually get in front of a judge who's appropriate to give you relief. So the key understanding in Texas is we have to have an avenue to get the right kinds of disputes in front of the right kinds of judges. And that's what we've done with the business court. It's an evolving situation, and it has a limited jurisdiction. But right now, if it's a dispute that involves a sufficient amount in controversy and involves business, and we're not going to make this a seminar about the business court, but there's a statutory scope for that court, but it's the threshold is low enough that most commercial transactions of consequence will qualify. And so people can know now that there's an opportunity to get a dispute in Texas in front of those business court judges. And living here and seeing it play out, the court's just been in place for just over a year now. There's a lot of excitement about it. The legal community is following it very closely. I see news articles every day about the newest trial or the newest thing that's happening. And then I think maybe the most exciting thing for our audience today in our conversation is that in the recent legislative session last year, so this was the first session after they created the business court, the legislature has already tweaked the International Arbitration Statute to ensure that the business court will have concurrent jurisdiction with the other district courts to do things such as compel arbitration, enforce awards, vacate awards. And so to the extent there was a question in the past of whether you could get in front of the business court in aid of a international arbitration, that's now expressly provided for. And I think this is an opening that we should be looking to get other improvements to the International Arbitration Statute.
So the business court will, in your opinion, will improve the arbitration in Texas?
I think so. I think it makes it more attractive as a seat because if you've got a dispute of a sufficient size, and frankly, I think that's generally what the kinds of disputes we're talking about when we have this conversation, you know that you're not going to be trapped in front of a judge that is inappropriate for the dispute. And I don't say this to disparage any judge anywhere. It's just the reality that certain disputes benefit from having judges who have the appropriate experience. And to the extent that hasn't been there in Texas in the past, it's there now. And people know it's there now. And it's a reason why people are bringing more business to Texas. And we see it in the headlines, major companies reincorporating in Texas, a stock exchange being launched in Texas. There's a lot of great momentum here. And as we have more international commerce in Texas, we need the infrastructure to appropriately support the disputes.
It's very interesting, Michael, what you're saying, because as a French lawyer, everybody knows that French law and Paris is very modern as to arbitration, very arbitration friendly. But I see a lot of similarities between the French law and Texas law, because Texas law, as a French law, has domestic and international arbitration statutes. And what you're saying about the Texas Business Court, that reminds me of the Cour d'Appel de Paris, where they have the specialized arbitration business judges which can take care of sophisticated disputes. But you suggested that we talk today not only about Texas International Arbitration Statute, but also how we can make it better.
Absolutely.
Right? So it seems like Texas International Arbitration Statute hasn't been changed since 1989, and jurisdictions like United Kingdom or Singapore have modernized there. So everybody knows that there's a new UK Arbitration Act 2025. How significant are the gaps of Texas arbitration statute in comparison to these jurisdiction statutes?
Well, you're right. This is, I think, a conversation that we need to have in Texas. Let me start by not selling ourselves too short, because only 7 states in the United States even have their own International Arbitration Act. So we've got that, but I really think that is the bare minimum that we should have to be taken seriously, that we understand the importance of having law that supports international dispute structure. And it's not that there's been no change, because as I just mentioned, there have been some tweaks made to tie the business court into the International Arbitration Statute, but there's not been a comprehensive updating of this statute since it was originally enacted in 1989, and that was based on the original UNCITRAL model law. Well, the model law has been substantially revised itself. And so if you think about this, I mean, we've had the original model law is now over 40 years old. And there are aspects of it that just simply have not kept pace with advances in technology and how business is done and how disputes are handled. We were using fax machines in 1989 when this law was passed. And so one of the most important changes in the 2006 revision to the model law is it updated some provisions about what's required for a written agreement, and particularly to expand what can qualify as an enforceable written arbitration agreement in electronic form. And these are pretty fundamental and not controversial upgrades to the statute that we simply haven't adopted yet in Texas. And so just as sort of good governance and housekeeping, bringing these things up to date, I think is the bare minimum that we ought to be advocating for in Texas as an international arbitration community. But if we're going to be engaged in this process, I want to propose we take the next step forward, which is we can look around the globe and see what the best practices are. We know what's happening in the UK, we know what's happening in Singapore, and we can see how the community is reacting to all these innovations. There's no reason why we shouldn't be enacting them into our Texas International Statute as well. That's the whole reason we have that statute, so that Texas can be an innovator, and so I think there's a lot of great things that have been happening globally that are very ripe for inclusion in our statute.
Other interesting things which the UK has adopted recently is the special express provision on emergency arbitrators, right? And not a lot of people know that ICDR, the American Arbitration Association International Branch, was the first one who created the emergency arbitrators. So do you think that will be beneficial for Texas to insert some emergency provisions? And if yes, how do you envision them?
Yeah, absolutely. Well, so when you look at arbitration agreements, they often, even though they call for arbitration, they also make allowance for the fact that somebody might need to run to court for some kind of interim relief. And I think the reality of those of us who practice in this area is, it can often take weeks, months to get a tribunal into place. But there are many disputes, and particularly in high stakes energy disputes, there's a need for immediate relief, and our arbitration community has responded to that need with the emergency arbitrators, and now every major institution has a provision for emergency arbitrators. It's very helpful to know, for the users of arbitration to know, that you can rely on that emergency arbitrator, and that the relief you get from an emergency arbitrator will be respected by and enforced by a court. There can be a question about whether some kind of interim relief from an emergency arbitrator qualifies as a formal final award that is entitled to all of the procedural protections that are available for enforcement. Well, we need to eliminate those questions. We need certainty for the users of arbitration. And this is why it's a good idea to acknowledge the reality of emergency arbitrator practice and have a statute that acknowledges that the orders from emergency arbitrators should be enforced.
And also facilitating the emergency arbitrators. Right?
Absolutely.
I don't want to make this a comparison lecture between UK Arbitration Act and Texas Arbitration Act, but it's true that the UK Arbitration Act was updated very recently, so it kind of contains a lot of innovative moments there. And another interesting provision is the default rule on the law governing the arbitration agreement in the updated UK Arbitration Act. First of all, we have some students as our audience today. Could you please explain what's the default rule? What does it mean? And also, how can we adapt it for Texas law?
Sure. So this is the kind of thing that lawyers who love the law can really sink their teeth into. But for those who follow it, a very famous case out of the UK called Enka versus Chubb, that addressed the question of, when you have a contract that does not specifically state what the law of arbitration is going to be, what should the default rule be? You may have a contract that says we're going to have Mexican law will be the substantive law, but the seat of arbitration is going to be Houston, Texas.
That's the ideal situation for us.
But so if it doesn't specifically specify, does the choice of law for Mexican law mean that you look to the law of Mexico for the law of arbitration, or does it mean, or does the choice of Houston as the seat mean that you're choosing Texas law? And we won't get into all the details of the reasoning. It's a very interesting decision that came out of the UK. But the upshot is that the law in the UK has been updated to provide us a very predictable and simple and sensible rule, which is that the default standard is that your seat of arbitration provides the law of arbitration, unless there's something else in the agreement to suggest otherwise. And it's a sensible standard that has the potential to eliminate a lot of tertiary disputes about, figuring out what law applies. A clear, easily administered standard, something that's now been done in the UK and would be a great thing to add to our law in Texas.
Thank you so much, Michael. And another last question about the UK Arbitration Act. So the newest update of the UK Arbitration Act grants the tribunals express authority to dismiss claims summarily. So should we consider that reform as well?
I think so. I think there's something very interesting culturally among arbitrators, because I think some arbitrators are naturally hostile to dispositive motions, and I've written about this. I think every dispute is different. Arbitrators should be impartial and neutral about whether dispositive relief is appropriate for a dispute. But one of the objections is essentially a due process concern that, is there a risk if an arbitrator grants a dispositive motion that the award will be subject to challenge because party didn't have a full opportunity for a hearing? And all the surveys of arbitration users show that, there's strong support for the availability of summary relief for claims or defenses that are manifestly proven as a matter of law or disproven as a matter of law. And so the 2025 Arbitration Act in the UK expressly recognizes that arbitrators do have this power. And I think it conforms to practice, and it eliminates the uncertainty and removes an objection from some arbitrators about considering dispositive relief. And so I think it would be a great improvement.
Thank you. So we have a couple of questions left, but I also see that we have questions from the audience.
Okay.
So let's give it priority because it's always great to have people being interested in asking questions, right? So we have an anonymous attendee who's asking, does Houston/Texas have a landmark court case in arbitration matter that promotes it as a friendly seat for arbitration?
That's a good question. I don't have one on the tip of my tongue, and it's probably, especially for those of us who want to promote Houston as a friendly seat, it's a good thing for us to consider. I will point out there's one decision out of the Texas Supreme Court that I think really was innovative and put Texas ahead of much of international practice at the time. It's the Burlington Resources case, and it involves the standard for arbitrator disclosures. Texas is actually way ahead of the curve in terms of defining standards for what should be required for arbitrator disclosures. And our statute also, one of the ways in which the original model law was not copied in Texas is that our international arbitration law already codifies a very detailed set of standards for arbitrator disclosures. But this is an opinion that I would point to as one that shows the careful attention to ensuring that the arbitration practice is a good one. But I appreciate that question. I think we should be looking for it and looking for good candidates for how we can, it's a good question. Thank you.
Thank you. And we have another question. What does Judge Massengale, well, they ask about my opinion as well, but I would just give you the floor, consider to be one or some of the most impactful arbitration law innovations in jurisdictions globally?
Well, I mean, we're talking about some of the big ones, and they're really not. I think they're things that make a lot of common sense, but they're things that it's through our collective experience, they hadn't been reduced to statutes, and we've come to the conclusion some of these things are. One of the things that I think is really interesting, and at our International Commercial Arbitration Conference here in Houston last month, there was a great keynote speech about addressing abusive tactics in arbitration. And so the idea that we need to strengthen the power of arbitration tribunals to sanction parties that are engaging in obstructive conduct is something that should be taken very seriously. And institutions need to be looking at incorporating that into their rules. And then the statutes of the seats of arbitration need to clearly reflect the authority to enforce those sanctions. So,
thank you, Michael. So before I read the next question, which is more logistical question, not on the reform, can you please tell us what, in your opinion, if you prioritize 2 or 3 reforms of Texas Arbitration Act, what should it be?
Number one, at a minimum, we need to update our statute to reflect the 2006 UNCITRAL model law. So that should be a no-brainer. That's the first step. Beyond that, I think express authorization for emergency arbitrators, adopting this standard of the law, the choice of the seat establishes a default law of the arbitration is one. Summary dismissal powers expressly recognized by the statute. We need improved protection for arbitrator immunity, because if we want arbitrators to make the disclosures that they're expected to make, they need to not have fear that they will be exposed to either the expense of the proceeding to replace them or any other kind of civil liability for doing what they're supposed to do in terms of disclosures. That's very important. And the last thing is I would really look at putting some teeth into arbitral sanctions.
Arbitral sanctions. Can you please explain?
If there is abusive conduct, there needs to be both institutional rules that enable arbitrators to deal with them effectively. So, for example, if the appointment of the arbitrator is being abused, there are reports that strategically arbitrators have resigned in order to delay proceedings. Having as a potential sanction, depriving the appointing party of the right to appoint another arbitrator is a way to combat these abusive tactics. But right now we don't necessarily have, there's always a concern when we talk about sanctions in arbitration. Where's the authority come from, and will it be enforceable? That's why we can have great rules, but if there's not a backbone that allows a court to enforce a sanction, it may be an empty promise.
So you mean effectively fighting the guerrilla tactics, which
That's right.
are very popular in arbitration
That's right.
in some countries, right? So we have another question from William Russell this time. How does Houston compare to other common seats in terms of logistics and costs? Very good question. For example, flights, hotel costs, support vendors, experienced arbitrators.
Great question, Mr. Russell. Thank you. So, one of the great things about Houston compared to some of these larger seats is we do have lower costs, but at the same time, we have concentrated experience here. So you get access to the very best in terms of what the legal community and legal support communities have to offer at lower costs. Houston is a hub of international travel. I like to say, I don't recommend Houston for anybody's vacation.
Okay. Even if I would recommend it,
but when you live and work here, you know that you can get anywhere in the world very easily, and that's true for business, and it's true for pleasure, and it's very, very accessible and easy to access both from Europe and all of Latin America, direct flights to all the major Latin capitals. So those are among our many great qualities for having Houston as a seat of arbitration.
So we are still allowing questions, and I'll ask one very important question before we discuss the restaurants and other pleasant things. So, Michael, what can we realistically do to improve the Texas Arbitration Act? Can in-house counsel, the legal community, arbitration community do something to make it work and make it even better?
Absolutely. Well, so I'm going to speak really candidly about this. I look around the country and around the globe, and I think we're not sufficiently organized and collaborating in Houston to promote our common interests, to promote Houston as a seat. We need to do that. And I think that if we can come together and collaborate on proposed reforms to this statute, this is a way that we can come together. We can raise the profile. Just the fact of doing this would generate great media coverage in the legal community for Houston as a seat of international arbitration. And we know how to access the legislature, and we've got an opportunity we can capitalize on now. I think the legislature is very focused on doing things that enhance the desirability of Texas as a place to do global business. This is right up the alley of our state leadership that is wanting to do this. I think the time is now, but we have to get organized. We need to find champions in the legislature to sponsor the legislation. But first, we've got to have a proposal. And I think we have some work to do locally to build consensus about what we want, and then a path to follow. But I think it's something that's very achievable. We just need to come together and start talking about it more.
Thank you, Michael. And you're doing great job in educating us, right, with your article on Texas Business Court and this webinar as well. I'm impressed how advanced we are actually, that we are at the same level as the French courts, right, at some point, and French legislature. Just we probably did not as good job as France did on the, marketing of our legislation. I don't see any other questions for now, so I'm passing to my favorite part of the webinar. So tell us, what are the favorite place in Houston to bring guests and clients food-wise?
Houston's such a great food city.
Exactly.
And I have a couple things to share. I've carefully studied the webinar series so that I can bring some additional. But these would all be my answers anyway. So first of all, if you're looking for that Michelin star quality fine dining experience, my favorite, and it's been my favorite for 10 years, and before it had a Michelin star, is a Spanish restaurant called BCN.
Oh, where's that?
It's in the Montrose area. It's an outstanding classical Spanish restaurant, white tablecloth, outstanding wine list of all Spanish wines. And I was not surprised that it was one of the 5 or 6 restaurants that got a Michelin star when we first got the Michelin ratings in Houston. Go and ask for Paco, the wine steward. He will give you the best recommendation for a wine to pair. And it's classic Spanish food, tapas. And I'm more of a wine person than a cocktail person, but some of the most beautiful gin and tonic cocktails I've seen in my life are served at BCN. Tex-Mex.
Tex-Mex.
I've gotten a little
Hochi. That's the number 2 for the webinars. So first, number 1 was Taste of Texas. Number 2 is Hochi. So
this is more classic Tex-Mex, and I've gotten a little fancy in my middle age, but there's a place called Armando's that the food is excellent. This is not a greasy spoon, but it's got a great neighborhood vibe, fantastic margaritas, classic Tex-Mex, and if I'm not going for the Michelin star experience, Armando's is my other favorite restaurant in Houston. And then I've got one other kind of place I really love to bring people, especially if they're in town for business, because it's easy to get to from downtown Houston. So Specs. is a chain of liquor stores
Right,
in
spec.
in
We've heard.
Texas. But the mothership of all specs is this gigantic store in Midtown, very close to the downtown area.
Mhm.
It's got an outstanding deli counter. So you can walk in and order an incredible deli sandwich. And while you're waiting, you wander over to one of the largest retail wine selections in North America. And as a person who loves wine, I could wander the aisles there for hours.
Do they allow tasting?
They host tastings, they do. But anybody I've brought from out of town has been blown away when they saw the size and scope of the specs in Midtown, and I recommend the deli counter.
Amazing. That's why I like these webinars. I make my own list of all the places to do in Houston, and maybe one day I will just publish a book on that. Arbitration cuisine, right? And we have one more question, more serious, from Richard Dirch. Um, Houston has several capable arbitrators for all types of commercial disputes, and that's true, as well as energy. What can be done so that Houston arbitrators are appointed to these more often? It seems like there are many hearings that occur here, but not using Houston arbitrators.
Gosh, I think it's a great question, and it's something that we have a common interest in thinking about. I think we want to be sure that we're giving our local arbitrators a platform, and I understand that sometimes when the more national or global conferences are hosted here, that there may be a little bit of a bias against having the local practitioners on panels. I understand from a certain sense that we want to have the right people speaking, but we need to use our platform to promote our arbitrators. And I think I would also say this goes back to what I was saying about I think we need to focus on collaborating in our local community better, so that we know each other and that we're comfortable recommending each other. That's one thing I love about arbitration compared to mediation is that we all have opportunities to choose chairs. People are always asking for advice or experience with other arbitrators. If we don't know each other, we can't share that wisdom. And I strongly believe we need to work harder at creating opportunities for us to talk to each other, get to know each other. That's why I think let's grab a common cause. Let's get this statute enacted, and let's push Houston forward, because we have a lot going for this city. The arbitration practitioners in this town are second to none, and it shouldn't be that way. I agree completely with Richard.
Uh, Thank you so much, Richard, for your question. I also have, well, we have another question by Denton Nichols, another Houston arbitration practitioner. What are some physical venues in Houston that you believe are well appointed to host significant international arbitration? JAMS has its new facility. That's true. That's where we are. Have you seen or heard of others that arbitrators and counsel really consider fit for this purpose?
Yeah. Great question, and I want to loop back to Denton Nichols, but I have, in fact, I have a hearing scheduled next week in one of the major downtown buildings. I think the address is 812 Main, but it's one of the newer Heinz buildings, and like the building we're in now, 609 Main, which is also a Heinz building. Both of these buildings have large conference facilities that are available for rent. And I went and toured the facility a block and a half from here for our hearing that's next week. It's really outstanding. It's really it's a large space. It's got breakout rooms. It's got a common area for meals. It's not purpose built for arbitrations, but the space is absolutely appropriate, and so I would look, to some of the newer big office buildings, and Denton is with Norton Rose Fulbright, and they're in a brand new building. I don't know if they have a space like that there, but I think it's a common feature. And I guess since we're on this subject of promoting Houston and its suitability to host these disputes, I think here's two things I haven't mentioned yet today. Houston Place of Arbitration and Houston International Arbitration Club. And there's lots of other institutions that we are kind of circling around that bring us together. But we can bring these resources together and make them available to people. There ought to be a place that everybody knows to look and see the list, and that's not hard. We're just not doing it. Last thing I want to say is I'm so proud. One of my former law clerks is now a leading international arbitration practitioner. And when Denton Nichols was my law clerk, and he came to me and asked me if I could help him find a job in international arbitration, I had no idea where to begin. I didn't know a single person to call. And he found his way into this field, and I'm so glad that I followed him into it because the people who do this work are incredible, and the work is so interesting. And so, Denton, thank you for the question.
Thank you, Denton, and thank you, Michael, for such an amazing webinar. We have one more question. So exceptionally, we will allow 5 minutes more today, but after this question, we will have to stop. So we do an appropriate podcast series, podcast episode, so people around the world can keep listening about Houston and, of course, Texas Arbitration Act. So our last question of today is from René de Liu Campos. Dear Michael and Dr. Daria, thank you, René. Congratulations on the webinar. Events like this are extremely valuable for our arbitration community in helping Mexican lawyers understand Houston as a reliable seat for arbitration, considering we are natural neighbors in cross-border disputes and commercial relations. So what can you tell us, Michael, about this comment by René that our Mexican neighbors are looking at us and waiting from us to act and help not only the U.S. legal community, but also the Mexican legal community?
I'm so happy that Renee is watching today, and thank you for your comment. Renee is a friend I've made initially through the Chartered Institute, and through these friendships that we form through institutions, we learn about what's happening in Mexico, the interest in the judicial reforms there, and the renewed interest in arbitration. We know that all eyes in Mexico are looking to Houston, and they are wondering, is this a solution for them? Does this solve concerns they have about the legitimacy of the judicial process? What can they learn from us about arbitration? Is Houston the place that they should be seating their arbitrations? And, I know these conversations are happening. We're all participating in these conversations, but I think it's just one more reason why, we in Houston and a community of arbitrators in Houston and users of arbitration in Houston, we need to bring these resources together, make them easily accessible. We need to be doing our part to market our city and all that it has to offer. And if we need to tune up the statute, we need to tune up the statute. We're in the best position to bring this information to the legislature and get it done. Let's do it. And that way we can look to our friends in Mexico City and elsewhere and say, bring your work, we'll work with you to make sure that you've got a great place to come get your disputes resolved. Thank you, Renee.
So let's do it, Michael. I think that's the best end of our webinar today by these words, right? And thank you so much, Michael, for coming here and sharing all your knowledge with us. As usual, the webinar will be available on YouTube. Please share with all your acquaintances and friends to let them know that we do have a modernized statute. We do have all the facilities here in Houston to help you. And it will be also on podcast, on Apple and Spotify.
Outstanding. Thank you. Thank you, Daria.